This Honorable Court of Criminal Appeals of Tennessee is now in session.
All right. Thank you, Mr. Hivner. Good afternoon. This is the second day, and I believe the last case on the docket today for the Tennessee Court of Criminal Appeals. We are dealing with a docket from Knoxville, and we are using Zoom to do that. And we're hoping to get back to our regular procedure in the very near future. But we are grateful to Mr. Hivner and his staff for working hard to let us set up this technology and help us with it. And also the staff of the AOC, including Jared Walker and Barbara Peck and others. So we're glad that we've been able to handle these oral arguments during the pandemic in a way that hopefully the parties get to be heard and we get to decide the cases pretty much the same way we would in normal times. Attorneys, the rules are the same as if we were in court, 20 minutes per side. We have read your briefs. I need to introduce the panel. My name's Robert Wiedemeyer. I live in Nashville. Judge Camille McLaughlin is on the panel today. She's from Memphis, and also Judge Ross Dyer, also from Memphis. So we're about ready to proceed here. I think the appellant, if you wish to reserve any rebuttal time out of your 20 minutes, if you'll tell me on the front end, I'll try to keep up and let you know when you reach your rebuttal time. I'll remind you that it is not a requirement that you use all of your time. So feel free to use as much of it as you wish. All right, I think that's everything. Mr. Hivner, any preliminary matters? Are we ready for this case?
No preliminary matters, Your Honor.
All right, if you'll be kind enough to call the case, we'll proceed.
State of Tennessee versus Thomas McLaughlin.
All right, and this is Mr. Walden, is that right?
Yes, Your Honor.
All right, you ready to proceed?
Yes, Your Honor.
Go right ahead.
May it please the court, I'm Zach Walden, and I represent the appellant TJ McLaughlin. And with your permission, I would like to reserve 3 minutes of my time for rebuttal.
All right, certainly.
And as a brief personal privilege, this is my first time appearing before the Court of Criminal Appeals. And while it's a little disappointing that this professional milestone for me is over Zoom rather than 2 blocks away at our lovely courthouse here, I am grateful on behalf of Mr. McLaughlin that this court has been able to adapt to this technology to ensure that justice can still be administered through these challenging times. All of us, whether in the context of cases we've encountered or news stories we've heard or even our personal lives, are certainly aware of many tragic, fatal car accidents. How often do we hear phrases such as, if only he had been wearing a seatbelt, if only he hadn't been drinking, or more often nowadays, if only they hadn't been looking at their cell phone. We know, as a matter of common sense, what substantial factors that contribute to an accident are. However, in the case of Mr. McLaughlin, the state has taken a new position, which is if only he had the new wheel tax sticker on his license plate, or if only he had paid the reinstatement fee for his revoked driver's license. But we know that that is not a substantial factor, and that is why we're here today. And I know that this court hears sufficiency of the evidence arguments frequently. It's often what appellants are left with when there are no other issues preserved or we feel like there's nothing else meritorious to present. However, respectfully, this is a case where there is a severe deficiency in the evidence that was presented at trial as it relates to the crime of vehicular homicide by recklessness. Mr. McLaughlin was convicted by a Union County jury after they heard evidence that he failed to maintain his lane by drifting over no more than a few feet for a brief moment. He was going about 5 miles an hour over the speed limit. However, these minor, at best negligent traffic infractions were not the focus at trial of the state's prosecution. Instead, the state asked for a conviction based on the argument that Mr. McLaughlin's license status was revoked, that the car was not properly registered, and that the license plates were not proper. The state also focused heavily on the presence of controlled substance in his bloodstream, yet that there was no testimony whatsoever that Mr. McLaughlin was actually intoxicated or impaired or affected in any way in his ability to drive. Of course, that's why Mr. McLaughlin was not charged with vehicular homicide by intoxication. As a brief preliminary matter, there's a discrepancy between the parties' briefs as to what the proper standard for evidence sufficiency is as it relates to vehicular homicide. Mr. McLaughlin suggests that Tennessee Code Annotated 3913-213A states vehicular homicide is the reckless killing of another by the operation of an automobile as the proximate result of conduct creating a substantial risk of death or serious bodily injury to a person. The state has suggested that they can meet their burden of sufficiency when they prove that the accused was operating an automobile and operating it under circumstances that manifested extreme indifference to the value of human life, and that a person was killed as a result of the manner in which the accused operated the automobile. However, these elements are found in State versus Braden. We respectfully suggest that the Braden elements were derived from TCA 39-231, which contained a similar codification of the crime of vehicular manslaughter, but was repealed in 1989. So we respectfully suggest that it would be inappropriate to evaluate the evidence using those elements. When analyzing sufficiency, we first have to look at what the state has set forth as the conduct at issue. I've categorized what the state claims as conduct into three categories. The first are compliance issues, driving on a revoked license, improper plates, and registration. These are status offenses. They are not affirmative acts. I respectfully suggest they are not conduct at all. On that alone, they fail to meet the standard of the crime of vehicular manslaughter. Further, to the extent that they are conduct, they're certainly not reckless because they do not result in a conscious disregard of substantial and unjustifiable risk. It cannot be anticipated that driving on a revoked license or driving without proper plates is going to result in someone's death. Then we get to the issue of proximate cause. The state contended at trial that Mr. McLaughlin's crash would not have occurred but for driving when he was out of compliance. However, that just is not the proper way to ask that but for question. Would this accident have happened but for his license being revoked? Yes, it would have. That was not a factor. But even with the twisted but for test, this is not proximate cause. It's not a substantial factor of the car crash. The harm could not be reasonably foreseen. The Court of Appeals in a civil context has actually examined this exact situation in Shorter versus McManus. Of course, they were evaluating it as mere negligence, which is a lower mens rea than recklessness, which we're considering today. And it's also considering facts only by a preponderance of the evidence. However, when the plaintiff in Shorter versus McManus put forward the argument that a suspended or revoked license contributed to an accident, the Court of Appeals called that argument incomprehensible. Yet that very argument that the Court of Appeals refused to consider as a proximate cause of negligence is what resulted in Mr. McLaughlin's conviction of vehicular manslaughter. The next category of evidence is the toxicology report. The toxicology report did find the presence of marijuana and methamphetamine in really, really small quantities. The toxicologist at no point offered any testimony that Mr. McLaughlin was intoxicated or impaired, or that looking at those blood levels that it would indicate that he was intoxicated or impaired or affected in any way. They failed to show causation. Instead, they just showed conduct, or really a suggestion that Mr. McLaughlin was using illegal substances. And as those two categories are really just noise, and I'll discuss later how that noise invited the jurors to make a lot of improper inferences to arrive at their verdict. But that leaves us with the third category of evidence of conduct that the state contends recklessly created a substantial risk of death or serious injury, and that's speeding by 5 miles an hour and failure to maintain a lane. The traffic reconstruction expert witness did not calculate a rate of speed, but he did state that the accident was consistent with Mr. McLaughlin's statement that he was traveling 40 miles per hour in a 35 mile per hour zone, and he noted the possibility that he could be going faster. However, we have seen time and time again in case law that mere speeding is not enough. Traveling above the posted speed limit, according to State versus Ghost, is a deviation of due care, but it is not recklessness. When we have seen these high rate of speed cases have verdicts sustained, we're looking at defendants who are traveling 30, 40 miles an hour in excess of the posted speed limit. They're traveling down the road at 100. That is not the case here. The other conduct is failure to maintain lane. And that's important that we properly categorize that. The state in their brief tried to contrast it with State versus Krasovic, which Judge McLaughlin was on the panel for, I believe. The defendant in Krasovic was speeding at 63 miles per hour in a 55 mile per hour zone, but they were actually trying to make a pass on a 2-lane road in a no passing zone with oncoming traffic on a blind hill at night when it was dark. That is a completely different situation when a vehicle moves from their lane of traffic completely to the lane of oncoming traffic with another vehicle running parallel to them, as opposed to a brief shift of the vehicle a couple feet over the center line. They're codified differently in our code of traffic offenses, and they're completely distinguishable here today. So what did happen here? What happened here was a matter of brief negligence. These are not the types of things that we're looking at in cases cited in our briefs and the state's briefs, such as State versus Branch, State versus Pena, State versus Krasovic, where we're seeing excessive rates of speed. We're seeing people traveling into oncoming traffic while trying to pass other vehicles. We see vehicles that aren't braking. We see vehicles where there are witnesses that they've been driving erratically for some sustained period of time. None of that is present in this case. Mr. McLaughlin briefly drifted over. He braked. That's another distinguishing factor. He braked, he swerved, he attempted to avoid this accident. This case is very, very similar to the facts of State versus Ghost, where this court held that evidence was insufficient to sustain a conviction. The defendant in Ghost briefly looked down, just as Mr. McLaughlin did. Mr. Ghost thought that he saw a lit cigarette on the floor of his vehicle. Mr. McLaughlin looked down to change gears because it was a stick shift vehicle. They both briefly lost control of the vehicle. Mr. Ghost actually went out of his lane on the one side, then overcorrected onto the other side. And he was traveling 10 to 13 miles an hour over the speed limit, which was substantially more than how fast Mr. McLaughlin was going. And the Ghost court held that an accused is not guilty of vehicular homicide if the evidence establishes that the accused's conduct merely constituted a want of due care, inadvertence, or inattention. And that's important because if the Ghost court held otherwise, or if this court holds otherwise today, it creates a precedent that virtually every accident that has an at-fault driver where someone loses their life can result in a reckless vehicular homicide charge, and that is not what our statute says. When we're talking about insufficient evidence, we have a standard where we talk about the rational trier of fact. So I guess it's upon us to tell you that the trier of fact in this case, the jury, was irrational. That's not saying that there's something wrong with the 12 citizens of Union County that sat before this case. So we have to ask, why did they act irrationally? Well, it's because they were coaxed down a path of irrationality, by what they heard at trial. So let's talk about this matter of revoked license. They invited the jury, the state did, to draw an inference. The records show that they drove it home time and time again. A revoked license is revoked by a court for a crime, specifically a prior DUI or a prior vehicular assault. We cannot presume that the jury is ignorant as to what driving on a revoked license versus driving on a suspended license means. And if the jury did have any doubt, the state kept telling them that TJ McLaughlin should not have been driving because the state of Tennessee told him, do not be driving an automobile. The exact quote was, "Don't do it. We do not want you on the roads of Union County, Tennessee." In some similar cases, the court has already found that introduction of evidence of driving on a restricted license is reversible error, including in State versus Fleece, and State versus Stromberg, which I believe Judge Wiedemeyer wrote the opinion for the panel. In both of those cases, the defendant testified and the state cross-examined the defendants regarding false statements they made on their application for a restricted driver's license. In the Stromberg decision, I believe Judge Wiedemeyer wrote that the unfair prejudicial effect of the evidence outweighed its probative value because they introduced evidence of that prior DUI through the inference of why his license was restricted. So the distinction here is without difference, whether it is a restricted license or a revoked license, both of which are consequences to the licensure status as a result of a crime of DUI, vehicular manslaughter, vehicular assault. I would also note that in Stromberg, nothing in the opinion indicates an objection was actually made to that question, yet the court still found that it was reversible error because there was no way to know that Mr. Stromberg received a fair trial. The distinction between those two cases are that both dealt with impeachment evidence under Rule 608B. However, 608B does not apply here as Mr. McLaughlin did not testify and there wasn't an issue of his credibility as it relates to the license status. So this is more of a traditional 404B analysis, in which case there is even less reason for the state to introduce evidence of a revoked license, except to ask the jury to draw the improper inference. Additionally, the toxicology evidence led to an improper inference. Because the state was never able to make the causation link between the blood levels and the effect on driving, the entire testimony was completely irrelevant. One of the reports was apparently irrelevant because the state's expert even said that this particular report doesn't mean anything about effect. It just shows that the person smoked or ingested marijuana at some point in time. Why was that introduced for any reason other than to prejudice the jury against Mr. McLaughlin? We have trace amounts of marijuana and meth and other reports that were introduced, but there's no testimony from the expert that at these levels that she could opine that this could have caused an impairment or effect on Mr. McLaughlin's ability to operate a motor vehicle. There's no testimony from the officers about physical signs of impairment or intoxication. The state just wanted to tell the jury that TJ McLaughlin was using illegal drugs. They wanted the jury to make that inference, even though they couldn't present the evidence to show it. And with that, I'll reserve the remainder of my time for rebuttal.
All right, thank you, Mr. Walden. General Brandon, good afternoon. You ready, sir?
Yes, Your Honor. Your Honors, and may it please the court, Cody Brandon for the state of Tennessee. We respectfully request that this court affirm the judgment of the trial court. First, Your Honors, to address some of the confusion over the elements of vehicular homicide, the state relied in its brief on State versus Braden. That was a 1993 published decision by this court that has not been overruled or abrogated in any way. And so the court relied on that as binding precedent. For a little more context of that decision, as opposing counsel noted, the vehicular homicide statute, along with many other criminal statutes, was rewritten and recodified in 1989. The defendant at issue in State versus Braden was convicted under the 1981 version of the statute. But of course, the case was decided after 1989 because Braden was a 1993 decision. The Braden court acknowledged the change in the statute and cited to both statutes when it set out the elements of vehicular homicide. Didn't make any comment about those elements changing because of the 1989 amendment. And there hasn't been a case that has acknowledged a difference in the elements since then. But with specifically with respect to that 1989 amendment, the 1981 statute, and I encourage Your Honors to take a look at that. That was codified at Tennessee Code annotated 39-2412A. That statute included the elements of, the text of the statute was vehicular homicide is the killing of another by the operation of an automobile as the proximate result of conduct creating a substantial risk of death or serious bodily injury to a person, under circumstances manifesting extreme indifference to the value of human life. What happened in the 1989 recodification is that the General Assembly replaced that last phrase, under circumstances manifesting extreme indifference to the value of human life, with the single word reckless earlier in the statute. And so if your honors do find that State versus Braden isn't controlling on this case, isn't binding precedent with respect to the 1989 version of the statute, the logical conclusion would be to replace the Braden test by altering the operation under circumstances manifesting extreme indifference with operation under circumstances exhibiting recklessness. And we think that test comes out substantially similar or more favorable to the state in this case. But any way your honors address it, the important question, both for this court and for the jury, was whether defendant's entire course of conduct was reckless and manifested that extreme indifference to human life. The defendant's primary error in sufficiency analysis is taking each element of defendant's conduct piecemeal and trying to prove vehicular homicide based on each of those individual acts, such as smoking a bowl of marijuana a few hours before driving, having meth in his system while he's driving, crossing halfway into a lane on a hilly back road as he crossed a hill, and driving over the speed limit on a hilly back road. And the jury was tasked with taking all of that conduct together and determining whether that conduct was the reckless killing of Roy Maples. This court should reject defendant's invitation to analyze those pieces of evidence piecemeal and instead look again at the entire course of conduct and determine whether a rational trier of fact could find that all of that evidence taken together was evidence of the reckless killing of another through the operation of vehicle. The state's position is that it is, that the crossing over the center line, speeding on a hilly back road, having marijuana in the system and admitting to smoking a bowl of marijuana at 10:30 that morning when the accident happened shortly after 3:45, and having meth in his system, and again, defendant's own confession being consistent with him being in the crash phase of a methamphetamine high that causes drowsiness and depressive behavior that could have affected his driving, that all of that evidence taken together was sufficient to prove and to sustain the jury's verdict of guilty on vehicular homicide. With respect to the admission of defendant's license status and the toxicology reports, neither item of evidence was objected to on 404B grounds at trial. And as a result, those 404B arguments on appeal are waived, and this court can't grant plain error relief because the record is not clear about what happened in the trial court, and the trial court didn't breach a clear and unequivocal rule of law. As the state noted in its brief, multiple cases have held that when a defendant fails to object on 404B grounds, it deprives the trial court of an opportunity to make a clear record about the findings that would be required under 404B. And so we don't have those findings in this case and don't have any balancing there. And the trial court didn't breach a clear and unequivocal rule of law by failing to sua sponte conduct a 404B hearing to elicit those findings. It was defendant's responsibility to bring that issue to the trial court. He failed to do so, and so he's prevented from making those arguments on appeal. Unless your honors have further questions about the sentencing issue in this case or any of the issues addressed already by the state, we'd respectfully request that this court affirm the judgment of the trial court.
All right, thank you, General. You've got your rebuttal time, Mr. Walden.
Thank you, Your Honor. Respectfully, I just really had to push back that Braden is still controlling precedent. The opinion was issued in 1993 after the 1989 statute went into effect, but that's because the acts in Braden occurred in 1988. So Mr. Braden was charged under the previous version of the statute, which is a different statute. It's a different law. It has different elements. It's similar. It has the same name, but I don't know of any requirement when the state changes the elements of an offense for the court to then need to go back and explicitly say that we're going to follow the new law that was passed by the legislature. I mean, it's been well over 30 years since this law was rewritten. Mr. McLaughlin was charged under 39-13-213. That's the jury instruction that was given by the trial court. If Braden is controlling precedent, I guess the wrong jury instruction was given. But I believe that is not the elements of the offense. I acknowledge they're similar. Perhaps I can even make a better argument for insufficiency under Braden, but that is not the state of the law in Tennessee today. I'm also unsure why the state continues to contend that each act of conduct, which is alleged to be the conduct that caused a reckless homicide, should not be considered individually as to whether it was a substantial factor in the death of Mr. Maples. That's what the statute says for us to do. That's what the pattern instruction says for us to do. And if we're looking at conduct that was improperly considered as reckless conduct that results in this conviction, that is the very definition of insufficient evidence. And unless the court has further questions, I believe that the parties have thoroughly briefed this matter, and I do really appreciate the court's time and attention here today.
All right. Seeing no questions from my colleagues, I do want to take a moment just to say, Mr. Walden, you've done an excellent job with your case, representing your client, filing a good brief, and making a very succinct, understandable argument on his behalf. So I look forward to seeing you in person sometime in court again. I hope this won't be your first appearance. And General Brandon, you've done a great job as well. Look forward to seeing you in person sometime too. You pretty much in Knoxville for your cases, or General, are you?
Mostly, Your Honor. Occasionally I get the privilege of arguing in other sections.
All right. Well, hopefully all three of us will get the privilege of hearing the cases in all three of our sections over the next few months. That's what we're hoping for. But again, thank you. We'll study the briefs and the record and take into account what you folks have argued here this afternoon and render a decision in a timely manner. And thank you again. Mr. Hibner, if you'll adjourn court for Knoxville, I guess, until